Commissioner Fielder is here.
Thank you, Commissioner Fielder.
All right, Commissioner Fielder, are you on?
Yes, sir, I'm here. Thank you.
Okay. Good morning. It's be a rough Tuesday. All right. It's time and place for our regularly scheduled business meeting. Today's date is October 4th, 2022. The time is now 9:30 a.m. I call this meeting to order. Would the other commissioners please join me in reciting the Pledge of Allegiance? United States of America, to the republic for which it stands, God. All right, thank you, commissioners. I would note for the record that Commissioner O'Donnell, Commissioner Pinocci, Vice President Johnson, and myself are present in the Bollinger Room this morning, and Commissioner Fielder is present via Zoom. So we do have quorum this morning. This is the time and place for public comment. I understand we do have one public commenter online. Ms. Zonfrello, are you on? Okay, well, let's do this then while we're waiting for her. Are there any public commenters in the room? Seeing none, what we'll do is if we see Ms. Zonfrello come on, we'll just break at that point in time for public comment. All right, there are no changes to the agenda this morning, so we're going to roll right into our action items. Action item number 1 is approval of the commission minutes for the week of September 26, 2022. Is there a motion? Is there a second? Commissioner O'Donnell has moved to approve the commission minutes for the week of September 26, 2022. Commissioner Pinocci has seconded. Any discussion or revisions to the minutes as drafted? Seeing none, all those in favor of Commissioner O'Donnell's motion to approve the minutes signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Motion carries unanimously. Minutes are approved. We'll move to action item number 2. This is approval of out-of-state travel. Mr. Rosequist.
Morning, Mr. Chairman, Commissioners. Staff request approval for Dan Sherwood to travel to Phoenix, Arizona, October 31st through November 4th to attend the 2022 annual meeting of the Association of State Rail Safety Managers. The Association of State Rail Safety Managers was organized to facilitate safe rail transportation and an effective relationship with the Federal Railroad Administration. The association strives to promote uniformity among states in the conduct of railroad safety regulation activities and coordination among state and federal inspection programs. The association also provides states a collective voice on important railroad safety matters. The annual meeting provides a forum for FRA senior managers and subject matter experts to address state issues and concerns, inform states of the FRA's regulatory agenda, and strengthen the partnership between the state and federal inspection programs. This year's meeting will address, among other things, rail transportation of crude oil, coordination and communication between FRA districts and states, joint inspection procedures, state program best practices, and risk reduction programs. The FRA considers these annual meetings an essential element in maintaining a cohesive state participation program. The cost of this travel will be reimbursed through the Commission's Federal Railroad Safety Grant. The expected cost is approximately $1,500 and staff recommends approval, Mr. Chairman.
Is there a motion? Commissioner O'Donnell?
Mr. Chairman, I recommend approval of this travel expense.
All right, is there a second? Commissioner Pinochi has seconded. Discussion?
Mr. Chairman.
Commissioner O'Donnell?
Yeah, I think this is incredibly timely, having you do just in light of the derailment last Friday. Just that I'm really pleased that Mr. Sherwood is planning on going to this thing. Continuing education is key to accident prevention. So I'm very happy to support this.
Additional discussion or comment?
Mr. President.
Commissioner Fielder?
Thank you, Mr. President. I'd like to thank staff for the detail they provided to us regarding the purposes for the travel. And this was what I was sort of getting at last time we had a travel request before us, is the specifics of what benefit it is to the agency so that, we know, we can make an informed decision regarding the travel. So I'd like to see future travel requests include some kind of detail like this in terms of what the staff member will be participating in as far as their educational or professional development. So thank you, Mr. Rosequist, for putting this together for us so we clearly understand what it is we're voting on today. Thank you.
Additional discussion or comment? Seeing none, all those in favor of Commissioner O'Donnell's motion to approve staff travel signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Rosequist. All right, let's move into our work session items. Work session item number 1 is docket 2022.06.063, Energy West Montana. Annual Universal System Benefits Reconciliation Application. We're here to consider the proposed final order approving EWM's application, which includes a waiver of the minimum USB collection rate. Laura.
Morning, Mr. Chairman, Commissioners. By way of quick background, Energy West Montana, or EWM, filed its annual Universal Systems Benefit, that's USB, reconciliation application covering its Great Falls, Cascade, and West Yellowstone divisions on June 1st, 2022. Montana Consumer Council and Energy Share of Montana both intervened in the matter, but neither one submitted any data request and no one asked for any additional process. So this is an uncontested matter. In your reading materials, you will see a draft order that incorporates staff's recommendations regarding Energy West Montana's application. The draft order approves Energy West Montana's application and it grants EWM a temporary waiver of the requirement in Montana Administrative Rule 38.5.7020 Subpart 2 to maintain at least a 1.12 USB collection rate for its Great Falls Cascade division for the period April 1, 2022 through March 31st, 2023. The waiver is necessary because EWM has requested to set its collection rate for its Great Falls Cascade division at 1.07%. This rate will allow EWM to collect the $426,000 it projects it will need to cover its USB disbursements for those divisions for the period April 1st, 2022 through March 31st, 2023. Now, I'll note for you all that staff did take a close look at this $426,000 projection that EWM presented. And it's actually sent out a data request about it, and the staff saw no issues with it at all. The determination made by EWM properly used forward gas prices, and it also increased its projected disbursements by $72,000 since last year's projections. And the bulk of this $72,000 was primarily due to anticipated increased participation in its low-income discount program. So with that, I'd be happy to answer any questions the commission might have about the draft order, which staff recommends the commission adopt as the commission's final order, and authorizes staff to make edits to the order to improve clarity without changing the disposition.
Thank you, Laura. Is there a motion? Commissioner Pinochi.
Thank you, Mr. President. I move that we adopt staff recommendations and allow them to make changes if needed. Thank you.
That motion has been seconded by Commissioner O'Donnell. Discussion? Commissioner O'Donnell?
I looked into this pretty thoroughly, and it's really interesting to me that this is the first time in my few years on this commission that nearly 6 years that somebody has a utility has asked for under collection of what they're authorized or even mandated to do. I applaud Energy West for this. Instead of going the route of going the minimum, coming up with an over collection and returning it back, I think this is very prudent, and I really appreciate their application on this, Mr. Chairman.
Additional discussion? West Yellowstone is in my district, and I recall having this discussion a year ago. It's my understanding that for the West Yellowstone division, there continues to be an over collection of these funds. Is that correct?
That's my understanding, Mr. Chairman.
And then it seems every year we authorize them to issue a refund of the over collection amount.
That is my understanding as well, Mr. Chairman. I do note that they do project a slight over collection for this upcoming projected period, but we'll see how that all plays out in the end.
Can you explain to the public how the refund process works?
I could try to do that, Mr. Chairman, but if Mr. Lynch is on the line, I'll defer to him about that, having far more experience in these matters than I.
President Brown, can you hear me?
Yes, I can.
Okay.
Go ahead and identify yourself, please.
President Brown, this is Stegan Lynch. And when you're looking at the West Yellowstone, so the first thing to keep in mind is it's kind of a seasonal community. So you're not going to have year-round participation like you would in other USB programs. So essentially what they do is they just give the money back. I mean, there's nothing that can be, I said, different. And it's tough to change it because you're using a very low USB collection rate, and you never know what you're going to get with kind of the quite seasonal turnout of customers.
So, Mr. Lynch, when you say giving the money back, my question is, to whom are we giving the money back to?
Let me double check that.
So, Laura, while he's looking up that information, suffice it to say that the overcollection is a result of the inability to use the monies collected. Is that correct?
Yes, that's correct. And you're correct, Mr. Chairman. Refund in the past has been given back to those who've paid in, overpaid.
And as I understand it, this is a statutory collection?
That's correct. The 0.42% is a statutory requirement.
So we have a continual problem of overcollection in West Yellowstone that just carries on from year to year.
Yes, Mr. Chairman, that appears to be the case. As you all probably know, the utilities attempt to try to have a zero balance at the end of the year, but that's difficult to predict.
So any change to correct this continual problem would be a legislative change, I understand then?
Perhaps, Mr. Brown, again, though, there's because you're predicting into the future with cost of gas changing regularly, I'm not sure that they'd ever be able to come 100% at zero, but I suppose it's something to consider. Thank you, Mr. Chairman.
All right. Thank you. Additional discussion? Seeing none, all those in favor of the motion signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you. All right, let's move to work session item number 2. This is docket 2019.06.034, Caithness Beaver Creek LLC. The petition to set terms and conditions of PPA. We're here to rule on CBC's objection to Northwestern Energy's compliance filing. Mr. Hamilton.
Thank you, Mr. President and Commissioners. As you're well aware, this case has a very long history in front of the Commission. Most recently, you received this case back on the second petition for judicial review with instructions to apply the 11 trading days to forecast future market prices that CBC had offered in the underlying docket. Northwestern did submit a compliance filing with a workbook and 10 power sim runs to explain the new calculation of avoided cost rates. We did receive an objection from CBC, arguing that Northwestern had applied the wrong forward market curve. That objection led to an oral argument, which the Commission held a couple of weeks back. And now you have before you in your meeting materials a draft order on the objection and a staff memo that briefly walks through the outcome. Now, because this is somewhat complicated, I will spend more time than I normally would introducing a work session. As you're aware, the key issue here, as far as staff can tell, is the correct length of the forward market curve. After the forward market curve ends, both parties begin escalating the price, the market price, according to the Henry Hub natural gas escalator. But depending on where you end that forward market curve, the forecast over the life of the contract will look different. The draft order begins by addressing CBC's argument, which is essentially that the Commission cannot reopen the record on this second petition for judicial review remand. And because the Commission cannot reopen the evidentiary record, it must use the original market forward curve that CBC submitted in evidence. The Commission previously addressed this very question in the first remand process when the Commission was directed to move from 4 years of market forwards down to 2. The Commission did so without reopening the record, and that aspect of moving from 4 to 2 was frankly unchallenged by any of the parties. In that first remand, though, the Commission did continue to apply the trading days that Northwestern had submitted into evidence on the basis that the choice of trading days was not properly appealed in the first petition for judicial review. That led us to the second petition for judicial review, where CBC challenged the use of Northwestern's trading days, some of which appeared after CBC's legally enforceable obligation date. The court determined that in order to enforce its decision on the legally enforceable obligation date, this Commission did have to use the 11 trading days submitted by CBC. As a sort of side element of that second petition for judicial review, CBC did ask the court to specifically order the Commission to use the original market price forecast that CBC had admitted into evidence. And in a footnote to its order, the court expressly declined to analyze that issue, finding that the Commission had, in fact, already assented to using 2 years of market forward data. So on the grounds stated by CBC's objection, staff's recommendation is to deny the objection because the Commission can adjust the appropriate use of data from this forward market curve based on evidence already in the record to suit the district court's order. The question, however, remains what the district court actually directed this Commission to do. And that question has been muddled over the life of the docket. Originally, CBC did propose to use forward market data through the end of December 2021. Technically speaking, CBC also proposed to start using that data in April of 2019, but the start date as a practical matter is unimportant. What matters is when you end using that forward market curve in order to calculate the future escalation of that forecast. So the draft final order walks through the history of the evidence in this case and explains how initially CBC's position in the evidence was very clear, that it proposed to use forward market data through the end of December 2021. As the case moved on through reconsideration of the final order, through the first petition for judicial review, through the process on remand from that first petition, and indeed through the second petition for judicial review, it started to become less clear what specifically CVC was asking for, because instead of keying their forward market curve to December of 2021, they began referring to a 2-year period. And of course, a 2-year period, traditionally speaking, is 24 months. What they had originally asked for was actually 33 months, spanning from April of 2019 through December of 2021. Because the district court in the first petition for judicial review in its order cited to that original evidence from CVC, staff believes that in fact the court was imprecisely or maybe in a shorthand fashion referring to a period running from April of 2019 through December of 2021 when it discussed 2 years of market forward period. That was, after all, the data that the court relied upon. It specifically cited to the testimony of CVC's chief witness on this issue, who advocated for the use of data through December of 2021. So the draft final order concludes that, in fact, the court's direction is to use data through December 2021 based on the citations the district court used in its order. And because of that, and because the commission's obligation at this point is to faithfully enforce the district court's orders, staff does recommend having Northwestern submit a new compliance filing that uses forward market data through the end of December 2021, and then begins escalating the forward market from there with the Henry Hub escalation rate. So that was a fairly long discussion, and I'd be happy to answer any questions that you may have about the rationale here. I would like to note, though, before I turn over the floor, 2 changes that staff has identified as necessary for the final order that would help improve clarity. First is at the end of paragraph 16. The sentence originally read, after December 2021, however, CVC's market price forecast escalated the forward price observed in December 2021 by the EIA AEO natural gas price forecast. And then it cites to Duran's direct testimony at page 9. After consulting with Neil Templeton in regulatory, we believe that it would be prudent to change that sentence to read, after December 2021, however, CVC's market price forecast began escalating according to the EIA AEO natural gas price forecast. And then to add in there a footnote that describes how the escalation rate is applied. The reason for this change is that the sentence as originally written could give the impression that it's an escalation that begins January 2022 by applying the EIA AEO escalation rate to the December 2021 price, and just carries on from there, escalating month to month based on the month prior. That is in fact not how the escalation rate is applied in these cases. You would always look back 1 year. So you're applying the escalation rate for January of 2022 to the observed market forward price in January of 2021. And by applying that on a sort of month to month basis based on the specific month that you're trying to calculate the price for, you preserve the seasonal fluctuations in prices that you already observe in the forward market. So that change would improve the clarity, we believe, of paragraph 16. One other change appears in paragraph 30. This is in the section of the order that actually describes Northwestern's obligation to submit a compliance filing. In the procedural order following the second petition for judicial review, the parties specifically agreed to provide not only the monthly workbook, but 10 power sim runs based on the new market price forecast to avoid potential issues of having to cover all that information again. Staff would recommend adding to the end of that paragraph, the final sentence, a requirement for Northwestern to file, again, monthly workbook data and data from 10 power sim runs. So the new final sentence of paragraph 30 would read, such filing must be submitted within 14 days of this order and must include the monthly workbook used to calculate avoided costs and data from 10 power sim runs. That concludes my presentation. As always, commissioners, happy to answer any questions you may have.
All right, thank you, Mr. Hamilton. Well done. And I'm going to move to adopt the draft order as amended as explained by Mr. Hamilton in paragraphs 16 and 30. I wasn't quite done, but thank you for your eagerness. So I'm going to move to adopt the draft order as amended in the two paragraphs noted as the commission's order on CBC's objection, and I'm moved to authorize staff to make further non-substantive edits to improve clarity and accuracy as need be before publication. Now, Mr. Vice President, you may second. Thank you. Motion's been seconded. Discussion. Commissioner O'Donnell.
Yeah, in reading this over, I was struck with the obvious efforts by staff to reconcile the record with the court order on there, and to be specific, the sentence in paragraph 27, although the court instructed the commission to use 2 years of market forward data, it cited evidence supporting a longer period. And I really appreciate staff just trying to get the flavor of exactly what the court meant on this thing and to come up with a reasonable solution to this. Thank you.
Thank you, Commissioner O'Donnell. Additional discussion. Additional discussion. All right. I will just note for the record at this point in time that I do intend and have already written a concurring opinion to the order that is before us. I am going to support my own motion because I believe it fairly and accurately implements the court's direction to the commission. So I believe we have met our legal obligations herein, but I would like to address, which I will in writing, allegations that were made by counsel for CBC during the oral argument on September 13th, 2022 that were levied at this commission. The allegations were disappointing and, in my opinion, bordered on unprofessional. And I will recite the following ad hominem statements that were made by counsel for CBC to this commission during that oral argument. I quote, "We're here today having to deal with these questions from the commission. I fail to understand the point of all this. I don't even know why you're worried about it. Maybe you wanted to have Northwestern have another bite at the apple. I don't know. It is not CBC's job nor my job to tell Northwestern what to do. It's their job and their lawyers to figure out what to do. Why are we trying to bail them out? I have my doubts that if my clients were in a similar situation, the same relief would be afforded." These were the statements made to this commission by legal counsel representing a party before this commission. Statements by legal counsel attacking the integrity of the commission have no place at oral argument or at any other time. And frankly, as I noted, are not congruent with the Montana rules of professional conduct. We as the commission do not expect parties to always agree with our decisions or our processes. So even so, the parties need to recognize the commission strives to issue decisions that correctly apply law to fact, as any other decision maker would do. In this vein, commission always welcomes and appreciates opposing argument as checks and balance against errors the commission may make. However, counsel's unfounded insinuations of bias demonstrate a clear lack of respect for the commission and do not in any way advance the interests of their legal clients. In the future, all legal counsel who appear before the commission would do well to remember their obligations under the rules of professional conduct, as well as respect basic concepts of civility and legal process, and to recognize the commission's legal authority in the bounds thereof. So I will be doing a concurring opinion on this matter. Additional comment? Seeing none, all those in favor of my motion? Aye. Aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Hamilton. All right, let's move to work session item number 3. This is Town of Saco Municipal Gas Pipeline Safety. This is commission initiated. We're here to consider issuing an order to show cause that the commission should not take steps to sanction the Town of Saco for failure to adhere to safety standards. Mr. Reed.
Thank you, Mr. President. The commissioners, of course, have read the memorandum that was prepared by pipeline staff and to a lesser extent myself. It's extremely thorough, I think, both in the breadth and scope. And I would like to bring the commission's attention to the very hard work that the pipeline staff has put in on this matter. This is an extraordinary request from staff because we're in a bit of an extraordinary situation. As the commission will note or will have noted from the memorandum, staff has been trying to get Saco to comply with the federal and state requirements for safety reporting and reporting of preventive maintenance checks and services for quite a long time. Saco has not complied. We have, since the 21st of September, been in talks with Saco about how they can come into compliance, and the result is a proposal that unfortunately we got late last week. It is an exemplar, or it roughly conforms to what staff believes Saco needs to have. The staff remain agnostic as to the source of this. It doesn't have to be from WSB. Saco has in fact passed a resolution proposing to hire WSB to engage in these sorts of activities. But at the time that Saco passed the resolution, they didn't have a price tag. So they knew they wanted to come into compliance, but they didn't know what it would cost. Saco has committed to working with Great West and WSB to get a plan like this underway. However, no contracts have been signed, and I think the Grinch of the bunch, in that I'm going to be the person to say that given Saco's track record, we have no assurance that if we don't actually give them a firm and specific deadline, I myself don't have an enormous amount of confidence that Saco is going to be able to comply. Therefore, staff recommendation is that the commission issue Saco an order to show cause that is as set out in the staff memorandum, with a time limit of 60 days, or with a hearing on this order to show cause roughly 60 days from today. If we can, it is our thought that this will give the town of Saco enough time to work with WSB to provide both a signed contract for services that are in accordance with their needs under the federal and state guidelines and requirements. And it will give time for staff to assess that, in fact, the program proposed by whichever vendor Saco chooses to select is in accordance with the with those legal requirements. I am open to questions, and any questions too hard for me can be addressed to either Mr. Tierney or Mr. Harworth.
Mr. Tierney, I'd like to hear from you on this matter.
Mr. President, we've been working with Saco for probably the last 3 to 4 years, and part of the breakdown came roughly 2 to 3 years ago. They've had a constant change of personnel, and that's where they began to struggle. And so Sam had spent quite a bit of time up there just in our normal inspection process, doing what we normally would do. And it became pretty evident that it was getting harder for them to comply. They just didn't have the personnel, didn't have the knowledge. And through this process, we've made them realize that, we've been working with them, but we can only work with them so far. I mean, they have to do their part to comply with the regulations. And I think they finally realized through the process of bringing in outside help that could set them on the path that they need to go down to comply with the regulations. And I've had discussions with town council members, and I believe that they're committed to this, as they feel, and as what we have said to them is that they need help to comply with the regulations going forward, whether there's personnel changes, excuse me, on a yearly basis. So I think that I commend them for doing this. I think that they've realized that they can't do it on their own, and they realize that this is the next step that they need to do. And I believe that they're committed to doing what they're going to do. And I think this is the right thing for them to do.
Thank you, Joel. Sam, anything to offer?
No, Mr. President, no, I don't.
All right, thank you. Is there a motion? Commissioner Panochi.
Thank you, Mr. President. I make a motion to support staff recommendations, and I have high hopes that who they're bringing in is going to get them into compliance. Thank you.
Is there a second? Commissioner O'Donnell seconded. Discussion. Vice President Johnson.
Thank you, Mr. President. Mr. Reed, just a quick way. Wait, first, I agree, you accept the checks in the mail just so many times, and then you move to another level. And I think this is wholly appropriate at this point. Is there a manner in which in the intervening 60-day period under the order, staff could determine that in fact compliance had been reached and thereby avoid the process of the hearing? Or do we have to in fact go to the hearing even to find out that, yeah, they finally did what they said they do?
Mr. President, Vice President Johnson, thanks for the question. I think it's absolutely incumbent on staff prior to the hearing to keep the commissioners apprised. What I would propose is that staff would be working with both the town of Saco and with whatever firm they contract with to have either monthly seems a bit sparse, but biweekly progress reports, or progress reports that would come at specific times once for example, specific deficiencies have been cured. I don't necessarily think that if the engineering firm comes on board and starts moving in a trajectory that is as we suggest, and we have no reason to believe that they are going to deviate from that trajectory, that we need to put everyone through the time and expense of a hearing. That having been said, one of the things that has been difficult for us to get Saco to do is to actually follow through. And our thought is that if we can see a contract, see that money has changed hands, that's going to get us about 80% of the way towards the hearing. But we do need to make sure that Saco is taking active steps towards compliance with the law.
Thank you. Thank you, Mr. President.
Commissioner O'Donnell.
So if after completing the contract or entering the contract with the engineering firm determines that the system cannot stand on its own. Mr. Tierney said part of the problem that they descended into was because they didn't have adequate staff. So if they do a one-time appraisal of the system and recommendations from the engineering firm, that's not going to change the staffing situation to maintain this. First of all, is there any other state agency? This agency is has its obligations pursuant to federal legislation, to PHMSA. Is there any state agency other than this one that has any oversight over this, or any part of this situation?
I believe no.
Hmm.
It's our jurisdiction.
At what point or what happens if like there was one of the statements in here that the PSC would determine whether or not the system had been abandoned. Okay. If such a determination was to come before us, what happens to the system if they just simply throw up their hands and they say, we simply cannot comply with all of this? What happens at that point?
They would have to go through the abandonment process that's required by code. And then they would have to make a determination what they're going to do with their customers. Their customers would have to find an alternative source, whether that would be moving to propane, whether that be moving to electricity. That's obviously what, we want to avoid. We don't want to do that. They will do this. They will do an evaluation of the system. One of the unique things about the town of Saco, and it's the only municipality we have in the state of Montana, is they produce their own gas.
Mhm.
They have 5 gas wells. And so obviously that gas field that they're right up there in the middle of, the wells are starting to deplete. And so they're going to have to look at the long-term viability of their wells and how they're going to supply the gas to their gas system. And that's something that would be an ongoing thing. And if they made a decision, since this commission has no rate authority over the town of Saco, we just have pipeline safety jurisdiction over them. If they made a decision as a town council and decided that we no longer want to be a municipal gas system, they could explore options of whether somebody else would be interested in purchasing it, like, whether they would want to abandon the system and go to other sources of gas. That would be a decision that they would make. But we wouldn't, that's not what our goal. Our goal is to get them into compliance. They would need to make that decision based on personnel, based on finances, whatever they want to base it on going forward as to whether they want to continue down that road.
So one other point here. So what you're saying is that basically there's protections in place that should the town of Saco not be up to fulfilling all the requirements here, that procedures are in place that the people in Saco won't be left without any way to warm their houses.
Well, what we would do, we would make sure that the system could operate on a safe manner until that they could make a decision and determine what they're going to do with their customers, whether they're going to switch to propane, whether they're going to
Well,
switch.
do we have the authority to tell them at some point to authorize them to go to propane or mandate it, or?
I wouldn't believe that the commission would have that authority. They could come to us and say that we've decided we're going to abandon the system. I don't know if the commission has the authority on a municipality to tell them what route they need to go to get an alternative source of gas.
Isn't this the same area where the farm tap customers had the same problem, and that MDU, I believe, was paying them to transition to propane?
Correct. There's another docket before the commission that we're working on now. It's I believe there's about 38 MDU customers that are orphaned on the Scout gathering system.
Mhm.
That the issue was that MDU or MDU Resources had sold their gathering assets to Scout a number of years ago. And so they have their own customers, kind of like the Haver pipeline system, but off the Scout system, that they have no control of those gas wells. And their proposal in that docket, which has not been before the commission yet, is to give each of these, I believe it's 38 customers, up to like $5,000 to convert their homes into a propane, basically, where they give them up to $5,000 if they need to convert their furnace or purchase a new furnace or hot water heater to. So MDU does, because MDU has no control of those customers on a system that they don't own. So it's kind of the same thing, because it's basically, it's the same gas field. And so I believe they're seeing, a decrease in the production of those gas fields. And so it's kind of like the same scenario, but a little bit different that the municipality owns the system here.
Okay, thank you.
Additional discussion, questions? Seeing none? All right, all those in favor of Commissioner Panocci's motion to issue an order to show cause and issue an order to show cause. Signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries. Seeing no further business to come before the commission, I'll just make a couple announcements.
Were you gonna see back if that commenter online has come back on?
Sure.
That is. Apparently she's not. Okay.
All right, so thank you for following up, Commissioner O'Donnell. Any further business before the commission? Our next commission business meeting will be Tuesday, October 11th, 2022. We will have a different start time. For those that regularly appear before the commission, we will be starting at 1:30 p.m. next Tuesday, not 9:30. So just please note that for your calendar. No further business. Time is now 10:16 a.m. I will adjourn today's meeting.